All right, welcome to Win Without Law School. I'm Arizona lawyer Julie Labenz. Today we are talking about trial skills, and we're going to focus on the pretrial statement. So anytime a case is set for trial, there's a requirement under the Arizona Rules of Family Law Procedure that the two sides file what's called a pretrial statement. It's a really important document. It lays out all of the issues in your case. It lays out the facts. It lays out your list of witnesses and exhibits, and it's a guide for the judge. So the judge will read the pretrial statement prior to the trial, and it gives them an overview of what is going to be presented at the trial. So this is your chance to try to influence the judge prior to trial by telling the judge what your positions are and what you want the judge to do. So it's a really important document. Okay. So you'll find the rule governing pretrial statements is this rule 76.1. So we're going to go through each part of this rule. Subsection A talks about a scheduling conference. Subsection B is about when the pretrial statement gets filed. Subsection C talks about whether it's a joint or separate statement. Subsection D talks about where to find a pretrial statement form. Subsection E is about a scheduling statement. Subsection F is about a notice of issues. Subsection G is about the pretrial statement. H is about what attachments to include with your pretrial statement. And then subsection I talks about what happens if you don't list something you intend to present at trial in your pretrial statement. So we're going to talk about each of these subsections. All right, let's look at A. So there is this type of conference called a scheduling conference, and the court can organize it, or either party can request it. Not every case involves a scheduling conference. However, if a scheduling conference is set, the purpose of it is for the court and the parties to formulate a plan for trial. And so this is where deadlines get put into place and everybody gets on the same page about how to prepare for this upcoming trial. The plan will include procedures for facilitating the admission of evidence and the filing of pretrial statements. So at least one of the attorneys who will conduct the trial for each party and any self-represented parties must attend this conference. So it's a required conference, and it's where the judge and the parties get together to put together a plan for trial. It does not happen in every case, but it would happen if either party requests it or if the court sets one up on its own. Timing. So unless the court orders otherwise, the parties must file a scheduling statement 20 days before the date set for a scheduling conference. So if a scheduling conference is set in your case, then a scheduling statement will be required. Also, 20 days before trial, the notice of issues has to be filed. We're going to talk about that more when we get to subsection F. And then a pretrial statement is filed 5 days before trial. So once you have a trial date set, you'll want to put on your calendar 20 days before trial as your deadline to file your notice of issues. And then you'll want a calendar 5 days before trial to file your pretrial statement. Now, when you count the 20 days for when the notice of issues is due, that's going to be a straight 20 days from the trial date. But these 5 days before trial, those 5 days are just going to be days the court's open. It's not a straight 5 days. It's 5 days based on when the court's open. Let's look at subsection C. There's joint or separate statements. So unless the court orders otherwise, the parties may file joint or separate statements. If preparing a joint statement, the party who initiated the action must take the lead to prepare a draft joint statement and must communicate with every other party concerning the statement as outlined below. The party who initiated the action must provide their outline for the pretrial statement to the opposing party 15 calendar days before the trial. 8 business days or more before the hearing, the parties must exchange their respective portions so that the positions can be merged. The pretrial statement will be reviewed by both parties and filed no less than 5 business days before the hearing date. Every pretrial statement must be signed by each party or counsel, However, if the parties are self-represented and there is a history of domestic violence, the parties must file separate pretrial statements. Rule 76D forms. The parties may use the form of statement provided in Form 16, Rule 97. So if you go to the Arizona Rules of Family Law Procedure, go to Rule 97 and Form 16, you will find a proposed form. Okay, now the scheduling statement. If your case gets set for a scheduling hearing and you need to file a scheduling statement 20 days before the hearing, this is what needs to be included in it. A brief description of the nature of the action, each party's name and address, if not confidential, the name and date of birth of each minor child, the anticipated length of trial, the parties' stipulations or agreements, detailed and concise statements of contested issues of fact and law, a list of witnesses each party expects to call to testify during the trial, a list of exhibits that each party may use, and then a statement by each party providing the status of discovery and disclosure, and a statement as to the parties' positions regarding processes to facilitate settlement. If a request for attorney's fees will be made, that needs to be indicated in the scheduling statement as well. So this is not going to apply in every case, only cases where a scheduling hearing is set. If a scheduling hearing is set, then 20 days before, you're required to file a scheduling statement that includes numbers 1 through 12, your positions on each of those. Okay, now this is important, the notice of issues. This is under subsection F. So there is a set form. You could find that in Rule 97 of the Arizona Rules of Family Law Procedure online. Look at Form 18. The notice of issues must contain a complete list of all remaining contested issues the filing party intends to present at the trial. Issues not raised previously cannot be raised for the first time in the notice of issues. Each party must file a separate notice of issues. Issues listed in the notice of issues are listed generally. Specificity is reserved for the pretrial statement after the parties and/or their counsel, if represented, have met and conferred to narrow or resolve the contested issues before the generation and submission of the pretrial statement. Neither party is required to file a notice of issues before a temporary orders hearing or other interim hearing. So this only applies to your final trial, and this has to be filed 20 days before your trial date. And it's where you list out each contested issue in your case. Once you exchange that with the other, it gets filed with the court and exchanged with the other side. And then the two sides are supposed to talk and see if they can resolve any of the contested issues on the list. Okay, the pretrial statement. So this is subsection D. And if you're going to do, or if you're required to do a pretrial statement, this is what needs to be included in it. Number 1, a brief description of the nature of the action. Number 2, each party's name and address, if not confidential. Number 3, the name and date of birth of each minor child. The parties' stipulations or agreements. A statement of uncontested facts or law. Detailed and concise statements of contested issues of facts and law. A position on each contested issue. So what is happening here in the statement is, number 1, you're specifying for the judge what is not contested. So what are your stipulations and agreements? What are the uncontested facts and law? And then you're also detailing what is contested. What are the contested issues of fact and law? And what is your position on each contested issue? If spousal maintenance is at issue in your case, you need to include the amount and duration of support sought. If parenting time is at issue, you'll need to include the schedule of parenting time you're requesting, including holidays and vacations. You'll need to list out all of the witnesses you intend to call at the trial. If there have been any depositions in your case, you'll need to indicate what parts of the deposition testimony you intend to use. You need each party's list of objections to any witnesses and the basis for each objection. You need a list of exhibits that each party intends to use at trial, and specifying exhibits that the parties agree are admissible, and then listing objections. a statement regarding the status of pretrial discovery and disclosure, a statement regarding good faith settlement negotiations, any request for attorney's fees, and finally, a statement about how the record of the trial will be made, which can be through a court reporter or through the FTR Gold recording system. So this pretrial statement is long, it's comprehensive. If you're doing a joint statement, it ends up having a lot in it. So we did have a question here. These rules apply to all trials, even modifications and enforcements. Yes. Now, this is going to be a final trial of a divorce or custody case. Regarding a modification case, you'll have to see what your judge orders. A lot of judges like these pretrial statements. I like to do a pretrial statement before any trial, whether or not the rule totally requires it or not, because it's such a useful tool for the judge. But this is 76.1, so it's within the rules prior to the Rule 91 modification rules. So I'd have to look in there and see if there's a direct requirement for a pretrial statement. But overall, you're going to see what your judge is ordering, and you can always ask your judge if a trial is set, hey, do you want the parties to do a pretrial statement or not? Okay. Now we're going to look at 76.1H. And what you'll see here is that there's certain documents that are required to be attached to your pretrial statement when it's filed with the court. So number one, if child support, spousal maintenance, or attorney's fees are at issue, and if the statement is submitted prior to a scheduling conference, then you want a summary of income and expenses. But if your pretrial statement is submitted prior to trial, then you need to include your affidavit of financial information as an attachment to your pretrial statement. If child support is at issue, you need to include a fully completed child support worksheet. If your case is for divorce, dissolution, legal separation, or annulment, you need to have the inventory of property and debts form. And the inventory of property debts form can be found under Rule 97 of the Arizona Rules of Family Law Procedure under Form 12, or you can make up your own, and it has to have this information: all community, joint tenancy, and other property and debts held in common by the parties, listing the separate property and debts of each party, listing any equitable lien claims regarding any separate property, including for each property the title by which the property is held, the amount of encumbrances, and each party's position regarding the value of the property, and setting forth each party's proposed distribution. So an AFI, if you've got child support, spousal maintenance, and or attorney's fees at issue in your case, a completed child support worksheet if child support's at issue in your case, and then a completed inventory of property and debts if you're facing a divorce, legal separation, or annulment. So those are going to be the documents that must be attached to your pretrial statement. All right, subsection I. What if you don't list a witness or exhibit that you want to use at trial? Well, the default rule is that you can't. If you don't share the witness or exhibit with the other side and list it in your pretrial statement, then the party may not present that witness or offer that exhibit unless the court orders otherwise for good cause. A party waives the right to raise an objection at the trial or hearing if the specific objection is not raised in the pretrial statement. A party may not present an issue not listed in either party's notice of issues at trial unless the court orders otherwise for good cause. So this notice of issues and the pretrial statement, those are both really important documents, because if you omit an argument, a witness, or an exhibit from the notice of issues or the pretrial statement, then you may not be able to use that witness or exhibit or raise that issue at the trial. All right, let's do a quick summary. Rule 76.1. Subsection A is about that scheduling conference. Either party can request that or the court can order it. 76.B is about the timing. 20 days before trial, the notice of issues is due. 5 days before trial, the pretrial statement is due. 76.1C talks about how your pretrial statement can be joint or separate. The starting point is that it should be joint, but if there's been domestic violence between the parties or there's a confidential address, it would be a separate statement. Each party would do their own separate statement. 76.1D explains where to find templates for these forms. 76.1E talks about the scheduling statement. If you have a scheduling conference set, you'll need to include all the info that's listed in subsection E, and you'll need to file that at least 20 days before the scheduling hearing. 76.1F talks about the notice of issues. That has to be filed at least 20 days before trial. You need to include all contested issues in that document, or you may waive it, or you may waive any unnamed contested issue. And then 76.1G, pretrial statement, file at least 5 business days before trial. 76.1H, that's going to be the attachments to the pretrial statement. Attach an AFI child support worksheet and or inventory of assets and debts, whatever is going to apply in your case. And then remember, if you don't list it, you most likely waive it. So make sure any arguments, any contested issues are listed in your notice of issues. Any witnesses that you intend to call to the stand are listed in your pretrial statement, and any and all exhibits you intend to use are listed in your pretrial statement. All right, that wraps up our lecture here on how to prepare a pretrial statement. If you have any questions, please bring those to the Q&A. Thank you so much.